So, a case challenging the NFA and its restrictions on SBS is now in front of the Supreme Court. And in this case, the Trump DOJ continues to argue against the Second Amendment. But now, the plaintiff is fighting back. So, let's talk about what is happening in this critical NFA/SBR challenge. Now, before we jump into this video, I want to ask you guys for a favor. If you like this video and you want to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, double check to make sure YouTube is not unsubscribed to you. They love to do that, especially on Tuwaya channels. And I want to thank one of the main supporters and sponsors of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AO is in a league of their own. And one of the cool things about AO is they're always expanding upon their benefit. They're always trying to improve upon their program. And if you're interested, you can check them out using the links down below. You can sign up using my code ERMSScholar, and that will get you $50 off an individual sign-up plan or $25 off of a family plan. Now, as I mentioned in the intro, in this video, we're going to be talking about a very important NFA challenge. And this case is currently in front of the Supreme Court. The challenge that we're going to be talking about is called U.S. versus Rush. And again, it's a challenge against the NFA and its restrictions on SBRs, also known as short-barreled rifles. This challenge asks for the Supreme Court to finally find that the NFA's restrictions are unconstitutional under the Second Amendment. Now, this petition also focuses on the Supreme Court finally stepping in to correct a lot of the lower court confusion and defiance that's going on right now in regards to what are arms protected by the Second Amendment. Recently, we also got a response from the Trump administration. And in that response, they argue that the Supreme Court should deny review to this case because they believe that the NFA has at least some circumstances in which it can be applied in a valid way and therefore it should pass the facial challenge that's being brought against it. And even more interestingly, what they're also arguing is that the underlying question on whether SBS are arms and therefore protected by the Second Amendment is a question that should be addressed in a different case. The Trump DOJ actually calls for the Supreme Court to take up that question in a different case, maybe dealing with state bans on AR-15s, but instead, review those cases, but do not grant review to this case dealing with SBS. Now, in response to that, Mr. Rush and his attorneys, which he's backed by the NRA in this challenge, they're fighting back against those Trump DOJ arguments, and they're pushing for the Supreme Court to grant review to this critical NFA challenge. Now, for those not aware, in this case, Mr. Rush was charged with possessing an unregistered SB in violation of the NFA. Now, back in 2022, a police officer saw Mr. Rush. He didn't have a driver license at the time. It was actually revoked. He pulled into a driveway within his truck, and then he walked across the street. He went into a courthouse for an appearance. Now, after leaving the courthouse, he walked across the street, went into an apartment complex, and then about an hour later, his sister actually left that same apartment complex, got into the truck, and drove away. Now, the police officer eventually stopped the truck. He asked the sister to call Mr. Rush, and on the phone, Mr. Rush had the conversation with the police officer, and he admitted that he did drive the truck and then parked at the apartment complex, and he agreed to meet the police officer and to talk with him. Now, while this was happening and while Mr. Rush was coming to the truck, the police officer was scanning the vehicle. He looked inside and believed he saw marijuana in the center console, and because of that he began to search the truck. Now about that time Mr. Rush arrived, and while the search was happening, and then he decided to open the back truck door, and then he reached for something on the floorboard. Now there was a struggle that happened. The police officer then was able to handcuff Mr. Rush, and then as they searched the truck they found SPR on the floorboard, and Mr. Rush actually admitted that he was trying to grab the gun. He was trying to grab the rifle, and then tried to run away. Because of this, Mr. Rush was charged with possessing an illegal SPR in violation of the NFA. Now, Mr. Rush argued that the NFA's registration requirements infringes on his Second Amendment rights, and therefore the charge against him for the NFA violation should be dropped. The district court denied that motion and concluded that SBS are dangerous and unusual firearms and therefore do not have 2A protections. They found that these are not arms for the purposes of the Second Amendment. This was then reviewed and appealed to the Seventh Circuit, who on review affirmed that lower court ruling. The Seventh Circuit relied on the Supreme Court's precedents in U.S. v. Miller, and they found that Miller remains controlling precedent, and they believe that Miller stood for the proposition that short-barreled shotguns could be restricted, and therefore they also believe that could be applied to SBS. Now, that's not necessarily actually what Miller says, but that is what the Seventh Circuit used. And because of this, Mr. Rush has now filed a petition to the Supreme Court asking for them to grant review to this case and reverse that Seventh Circuit ruling. Now, in that response, the Trump DOJ argued that the petition should be denied by the Supreme Court because they believe the NFA is facially constitutional, at least some of its applications. They believe that it could be applied in some ways lawfully against criminals who want to have and possess these items, and therefore the facial challenge should fail. They also argue that this case is not the proper vehicle for reviewing and essentially deciding on what arms are protected by the Second Amendment. They argue instead that the Supreme Court should take up a state rifle ban case to answer that question instead. Now, like I mentioned, Mr. Rush has now responded to the Trump DOJ and their argument, and in that reply, he states that this court's precedent makes clear beyond a doubt that the Second Amendment's plain text extends primacy to all instruments that constitute bearable arms. Yet, the Seventh Circuit panel below denied that the National Firearms Act's registration and taxation requirements for SBS even implicates the Second Amendment's text. When the lower court's Second Amendment jurisprudence deems ordinary long arms to fall outside the text of the Second Amendment altogether, that is a sign that the jurisprudence has taken a dangerously wrong turn. This court should intervene. Now, here in Mr. Rush's response, they start by pointing out how far lower courts have actually gone to twist Bruin and the other Supreme Court precedents to protect these types of toy violations. They then go on to state that the government does not defend the panel's refusal to recognize SBS as arms and the feeble arguments it does advance in an attempt to justify the result below all fail. Its argument that Section 5861D's regulation of short-barreled rifles is consistent with the nation's historical tradition of arms regulations is based on a smattering of laws enacted 45 years or more after the Second Amendment's ratification, primarily by states in the slaveholding South imposing limits that are not remotely analogous. So here Mr. Rush undercuts the whole historical analogs and evidence that was put forward by the Trump DOJ to essentially try to justify the NFA. They argue that historical evidence is all later laws passed in specific states and it was based on discrimination. These are all the type of laws that have been rejected by multiple circuit courts and lower court. And here they're saying that the Supreme Court should also reject all of that evidence to justify the NFA. They went on to state that the contention that the U.S. v. Miller case necessitates rejection of the petitioner's challenge is equally unpersuasive. Miller in fact confirms that the relevant question is whether the arms in question are the kind in common use at the time, and its tentative determination that there was no evidence tending to show that this standard was satisfied by different types of arms. Short-barreled shotguns at a different point in time nearly 90 years ago is irrelevant here. The government concedes that the decision below raises fundamental questions about the application of the Second Amendment that has bedeviled the federal courts of appeals, and that may well warrant review by this court. They then conclude by stating that this is the perfect case to address one or more questions that essentially lower courts have been grappling with, and that is really important for the Second Amendment cause, and therefore they asked for the Supreme Court to grant review to this case. So again, a very important challenge that is now moving forward in the Supreme Court. The Trump administration filed their response arguing for the petition to be denied. And they also argued that the, arms question is a very important question, but that the Supreme Court here should address that type of issue in a different case, maybe dealing with state rifle bans. But they asked for the Supreme Court to reject this review of SPR restrictions. But now, Mr. Rush has responded by saying that all the arguments made by the Trump DOJ do not warrant the rejection here of the case. Instead, the Supreme Court should grant review to this challenge and address this whole arms ban question right.